If you count the 2 years of articles, that would make 18 years at the sidebar.
And how were your briefing patterns like? I remember attending some of the BLA meetings, and when we complained about colleagues not giving us briefs, they would laugh at us. We were complaining that they were giving almost all the briefs to some of them, almost all the briefs to our white counterparts. They would laugh at us and say, "Oh, yalamba." How did you brief people?
CJ, I did my articles at a law firm that was not very far from the High Court. And when I set up practice, I set up my practice 2 blocks away from the High Court for the simple reason that I realized quite very early in my legal career that if you practice next to the seat of the High Court, you would be capacitated, equipped in what you would call correspondence work. I did a lot of correspondence work, and that shaped my knowledge and legal skills substantively and procedurally. As far as briefing, CJ, I took a conscious decision back then that a brief from my office would not go to anybody but our Black practitioners who have struggled in the same fashion as I have. And I made it sure, CJ, at the time, that I should brief them on virtually everything. And CJ, because the women advocates were few, the likes of Advocate Isemenya and the others, and the former DCJ, they would send me a list of newly appointed or admitted women advocates. Then I would brief them. CJ, if you recall back then, to prepare particulars of claim, you would charge as counsel somewhere in the region of 60 Rand or 70 Rand or 80. And if I had given a junior counsel about 10 briefs from my office, I mean, it's about 70 Rand, it's quite 700 Rand, it's quite a lot of money then.
No, it was.
And unfortunately, CJ, I could not have the opportunity to brief you because you had to take off to Mafikeng. But the others I had.
Well, for what it is worth, Judge President Lambo did give me a brief, although I was in Mafikeng.
Oh.
And for how many years were you a High Court judge? In Gauteng?
I would say about from 9 years.
Well, we've had some challenges regarding reserve judgments in the Gauteng High Court. Did you have similar challenges at some stage of taking longer than is desirable to deliver judgments?
CJ, I was in the fortunate position that when I joined the bench, I was what they would refer to me as the last born of that division. So I tap a lot on the experience of senior judges, and I make it my business to trouble them and also ask them how over the years they have managed not to have reserve judgments. CJ, I may put it this way. A reserve judgment lives with you. Whatever you do, wherever you go, it's there. And I would liken it to and something that is unfulfilled, something that is an expectation that ought to come through. So once you have it, unfortunately, CJ, you can't rest. So I I delivered my judgment promptly.
Well, all manner of reasons were advanced by some for not being able to do so. Previous disadvantage and so on. All right, let me put it this way. How would you advise a newly appointed Gauteng Division judge to ensure that they don't stay as long as a year, 2 years, or more with a reserve judgment? What is it that they must be careful not to do? What is it that they must be alive to in order to live up to the expectation
CJ,
of the litigation?
I think the answer is simple. Scorn yourself delights. I'm an insomniac, CJ. I don't sleep. I sleep very few hours. So all my hours are for reading and writing those judgments. And the advice I would give to them, which I have given to them over the years, is after each and every hearing, go to your chambers, put the books away, write what you think transpired in court on that day. And once you can maintain and master that discipline, you already at the end of that day, you have something that you can work on. It could include evaluation, assessment, and summary of the witnesses. By the time you get to write the main judgment, you are half the way there. And CJ, I know it has been raised that because we come from previously disadvantaged communities, we may not be having the necessary experience to adequately prepare and deliver judgments promptly. I think, CJ, it requires self-discipline. Let's knuckle down and do our work. It will happen. I would go while I was in Joburg and inducting new judges, I would go as far as inquiring from them about the status of their reserve judgments, because I know it can be problematic. If you can, in that division in Johannesburg, if at any stage you can be carrying about 4 judgments, I was told you're not coping. So you have to avoid to have more than 4 judgments per term.
I don't want you to say anything that could jeopardize your relationship with colleagues. I don't want you to say anything controversial, but I would want you, as circumspectly as I believe you're capable of doing, to tell us how you managed to navigate your way around the challenges at the SCA. The challenges, I mean, and you don't have to touch on it, I mean, notwithstanding the number of complaints we have had at this forum about the so-called top 6 and how the so-called top 6 relates to junior judges and other judges. How did you manage to find your way around that space and be as comfortable as I understand you to have been ever since you got
there? CJ, for all my life, I've been an activist. And for me, I have never allowed anybody to trample on my toes, my head, and everything else. The advantage that I had when I went to the SCA is I had judgments which I wrote whilst at the High Court in Johannesburg. And those judgments preceded me in the sense that they were up there for appeal. And when I went there, the colleagues had a fair idea of who was coming to act. But I knew then, because I have been following the history of the SCA. CJ, just to digress a bit, I may say something just to indicate why I'm saying I have been an activist and also a judicial activist. Very early in my judicial career at the Gauteng High Court, we realized quite painfully that the SCA was not truly and properly representative. The only African judges were JP Mlambo, President Maya, the late Deputy President Mutiani, and Bati. The numbers troubled us. And because it troubled us, we were not prepared to be supine. And we took a concrete resolution that during one of the interviews of the JSC, because you would have to go to the SCA per invitation as in other courts. Then we had 2 or 3 judges, the late Justice Busielo, Justice Riti, and Justice Shongwe. We deployed them to the interviews. And so that when they were asked, why haven't you applied? Why have you applied? You have not acted. And they said, nobody has called us. And as a result of that agitation, the doors were flung open. And the likes of us had that opportunity to go and act. Otherwise, if we had sat back, one never knows what would have happened. Now, coming to your question, CJ, about the top 6. Yes, it is true. We had those problems, and we experienced those problems quite painfully. I witnessed, I heard, I experienced, and it was painful, CJ, when colleagues, especially junior colleagues like us and me, were subjected to unfair criticisms, unfair differentiation, unfair treatment by the senior colleagues. That troubled me a lot. And at any and every given opportunity that I heard, those top 6, they know very well that I raised issues with them, much to their chagrin, and I did not care whether they liked me or they did not like me. And that helped in a way. But they continued until when President Maya took over as deputy. We had a lot of meetings. And especially because at this forum, we were chastised as a court for not treating junior colleagues properly. And that worried us. And remember, CJ, I had been in that court since 2015. I acted for the whole year in 2014. The following year, I got appointed. And I know, and some members of the top 6 were opposed to my appointment at the SCA. But unfortunately for them, this body saw it fit not to consider their views misplaced as they were, and endorsed my appointment. So what President Maya did, which is commendable, we firstly had what you'd call your sensitivity training. The top 6 boycotted it. Then that first meeting, it was like we're preaching to the converted. And the problems, the wound kept on festering and festering. And then we realized we were not resolving this. And then we had another one in 2019. CJ, at that time, you'd recall, I was acting in your court. I specifically requested your permission to go and attend that meeting. And it was painful. I could not sit back and say, because I am now acting at the CC, my colleagues down there, they can do as they please. And I went to that meeting with your permission. It was a worthwhile meeting. Gloves were off. We told the top six, to excuse the word or the pun, where to get off. Justice Pete was also there. And some, there is this thing called unconscious bias. Some had it, some were just deliberate. And we talk about a variety of things. And the reason being, we could not afford to have this court all the time going the wrong way when all other courts are on the right trajectory. I am made to believe that subsequent to that meeting, attitudes change, but there is light at the end of the tunnel, I'm told. I keep in contact with that court all the time. One of the other things that I do, CJ, is I am in the induction committee at the SCA. The purpose being to anticipate judges who have been invited to come and act, to induct them, to prepare them as to what to expect at that court. I have done that, CJ, while still acting in your court, and I hope I did not breach any rule. And because it is important for me that my colleagues, black and white, understand the culture of the court and understand what is expected of them. And that has worked. And I've had good reviews, good feedbacks that at least things have changed for the better. So I'm not sure if I've answered your question, CJ.
No, you have. You have. The next question, please listen to it very carefully because it may be necessary that you decide to pass and not answer it. Please be alert to the next question. Some of us have things written about them as judges almost all the time, even lies. Why is it, if you know, that this shocking development around the top six does not seem to have received the public attention it deserves by the same structures that write a lot about us and interrogate and fabricate things about some of us, and that they were never, there was never a deliberate action to find them out, to name and shame them? Why does it look like there is some cover around this top six? Why does it look like there is no scrutiny over the top six? And the next question, and again, please, my brother, listen to it very carefully. Who is the top six? That everybody has been, that some judges have been complaining so much about. And if you are not comfortable to say who the top six is, please don't go there.
CJ, the issue about the top 6 is simple. I'll tell you. Let me first start to respond to your question about why they have not enjoyed the exposure that other colleagues have. CJ, it's a really
endured.
And okay, thank you for the emphasis. CJ, the answer is simple. We do not own the media space. And if we have control of the media space, we would be able to write about everything that happens there. People would write, because the top 6 then would include people of particular color. The media and everybody else would shy away from exposing perhaps the darlings of those people of the particular color. So that's what happens. So the likes of you, unfortunately, CJ, and some of us, if it's considered that we may have erred or misdirected ourselves one or the other, the media would have a frenzy over us. And it's a fact, it's a reality that has to be accepted. So that is why, CJ, you have not seen any reporting about it. And it also surprised me because the proceedings of the JSC are open to the public, but you will not see or hear anything written extensively and expansively about what is happening or the toxicity of the top 6 then.
Yeah.
Okay?
Yeah.
Now you wanted to know about the top 6.
If you are comfortable. If you are comfortable.
No, CJ, it's not a problem. The top 6 varies. It goes according to seniority. You would have your president, you get your deputy president, the next senior judge, and in their descending order. And it varies sometimes from one term to the other, in the sense that 1 or 2 senior judges may have gone away on long leave or acting in the
Can I be more pointed? Can I be more pointed? And please, again, don't answer if you are not comfortable. Who are the personalities who fall within the parameters of the top 6 that have been complained about? Because I don't want it to look like the judiciary is covering up anything. To the extent possible, if there are people known who are making lives of fellow judges uncomfortable, and it is possible to say, these are the people that have been complained about, it must be said. But please don't put yourself into unnecessary trouble if you have to avoid answering the question directly.
CJ, if I had been a victim of a backlash from the top 6, I would say Justice Spets, who's now in the top 6, has treated me badly. The problem with naming and shaming the top 6 is the complainants have not taken up the courage to say, this judge is the one who has violated me 1 or 2 things. So what I would be saying would be purely what I heard.
Okay.
Yeah.
Okay. No, I understand. Now, which judgments that you wrote as an SCA judge or even a high court judge, would you say it's so outstanding with all sense of humility, that it commends you for appointment to the Constitutional Court, and take it further to the judgment that you have written as an acting judge of the Constitutional Court.
CJ.
In other words, this is not time to try and be humble. You've got to brag. Leave it up to us to say, hey, but you blew your trumpet too loud, but it's the only opportunity you have to brag here.
Okay, CJ, thank you for the opportunity. Please indulge me.
I will.
CJ and the commission, many, many years ago, as an attorney, I will start by bragging from my position as an attorney and go back and later at the High Court, SCA, and the Constitutional Court. And in that way, you'll see my trajectory. And I think I would do justice by proceeding along that premise. In the early days as an attorney, like I said, CJ, my practice was about 2 blocks away from the High Court. There is a judgment that I was the instructing attorney in it. It's a seminal judgment in the law of defamation. It's a judgment by Cameron J, as he then was. It's Holomisa versus the Argus newspaper. It's on the law of defamation. That judgment is quoted extensively everywhere, and you cannot do any case of defamation without any reference to that judgment. It's a 1996 judgment, and I was still then young, CJ, and I am proud to say that is one of the most contributions that I made as an attorney. Again, CJ, I may emphasize that my counsel of choice, to respond to your question, whether my briefing patterns were skewed or not, Advocate Darlene Pofu was my counsel of choice then. And then our association as far as goes a long way. So I had confidence in him against a big newspaper with all the funds and everything else that he would do justice to my brief. And indeed...
Should we ask him to recuse himself?
No, CJ.
Okay.
Yeah. Then, CJ, I was appointed as a judge in the High Court. Very early in my judicial career, I was allocated, before that. It was unheard of when I started at the High Court that an attorney could be allocated agent court duties. I became a guinea pig. I was put in that court. And I'm proud to say that I acquitted myself very well. And with the result that, unbeknown to me, the powers that be decided that I should take up residence in that court. I was more in that court every second or every third or fourth week. That helped me a lot because it capacitated me. It made me a judge that I am today. And the sky did not fall. And as a result of that, other judges, other acting judges were assigned those duties in the agent court. And because I've succeeded, a mere mortal like me, why couldn't others succeed? Then I was allocated a matter of print media versus the Films and Publication Board. dealing with censorship, and also dealing with some constitutional issues of Section 16(2) of the Constitution of the Films Publication Board, which I declared that section to be inconsistent with the Constitution. That judgment was taken up on appeal to the CC, and the Constitutional Court confirmed my judgment. So in other words, CJ, I had knocked at the Constitutional Court very early in my judicial career. I then had occasion in the Agent Court to write a judgment on arrest suspectus Dei fuga. Those are civil debtors and civil imprisonment. The matter had come before a senior judge in the Agent Court, and the senior judge had ordered that the debtor be arrested, and the debtor was arrested at the Morningside prison cells. When my turn came for the Agent Court on reconsideration, once after the senior judge had finished his stint or his term, it filled me with a sense of uneasiness. And I said, this cannot happen. I ordered the immediate release of that person and wrote a judgment. And because the issue of the constitutionality of the section was not squarely raised, I touched on it and left it open. And CJ, you had occasion later to deal with the same principle in Malachi. And then you quoted my judgment authoritatively, and that gave me peace and happiness.
Well, I must confess at that stage that I don't remember having met you before. I don't remember whether I even knew your face, but anyway.
Our judgments met. So CJ, then whilst at the Joburg High Court, I was exposed or put mostly in motion courts, opposed, unopposed, and everything else. There is one aspect that I need to bring to the attention of the commission is a year after my appointment, that was when there was a course on fast tracking of women judges, and by Minister Mabandla and Chief Justice Langa, may his soul rest in peace. The women were then asked to come to the High Court in Joburg to be mentored. As you'd understand, some would be there and they would not be, their judges would not be having work. I looked out for the women, aspirant women. I remember I had one interesting insurance matter. I had the 4 women sitting just below aspirant judges. And then we went through the hearing and everything else. And then thereafter we would have discussions. And in that way, I empowered them. Remember, I was a year old on the bench. I was able to identify and understand that they are not there through any accident. They deserve to be there. And some of them are, or most of them are judges now, and some have followed me to the SCA, and some have acted in your court. So it was a pleasurable experience for me. CJ and the commission, the Joburg High Court prepared me for the SCA. Like I said, my judgments preceded me. I was exposed to a variety of cases. I was in the tax court. I did IP work. Then I had no experience at all with tax matters. I was thrown into the deep end, and I'm responding, CJ, when I raise the tax issues to the lack of experience or thereof. So I was put in that court with an experience, with a tax experience, one may recall it, limited to a postage stamp or to that return form. Then I was able to sit in that court, wrote judgments, went to the SCA, some of my judgments, some were confirmed, one was not confirmed, painfully so. And whilst at that court, then I was allocated one heavy tax matter. I think I need to say this because it gave me a sense of satisfaction that this is a tax matter which had been going on for more than 12 to 13 years. And it traverses a lot of countries overseas and everything else. And when the council approached me, they said they would take about 3 weeks to lead the taxpayer only. And I realized then that if one were to go on in this way, I'm going to be here for the next coming 12 years with this tax matter. So what I did, quite unconventionally, obviously with the concurrence of the council, then I said, would it be possible if I can give you a week to go back and reduce the evidence of the taxpayer into an affidavit? And they did exactly that. They reduced that evidence into an affidavit, and then it gave me an opportunity to read the affidavit, and I read the affidavit. It was in a more 2 ACLIVA files. And then we would start with cross-examination. So that's when cross-examination starts. After 3-4 days into cross-examination, the matter got settled. And it saves the fiscus a lot of money in terms of personnel and in terms of the refund to the fiscus. So this is the exposure that the Johannesburg High Court provided me with. I do a lot of training for the Joburg High Court. I still do. Now I am moving on to the SCA now. CJ, when I got to the SCA in 2014, I had missed the SCA bars in 2011 for reasons not relevant for the purpose of this commission, and which was painful to me, but I knew that my time will come, and it came in 2014. I was allocated 3 judgments in my first term. I wrote them all. One judgment went to the CC, and we were found to have been wrong. I was the scribe. I was set aside. It's Arun versus the City of Cape Town. And on the panel, I had Justice Nafsa, Justice Ponen, Justice Theron, who's now with the SCA, and retired Judge Willis. The judgment of the Concord was written by DCJ Museneke. And in the second term of the SCA acting, I had occasion to write a judgment, Pfeiffer versus Van Wyk, a judgment dealing with enrichment lien. Then The second senior judge suggested that we should give an extempore judgment. And the term there is to imp it. I refused. Remember, I was number 5, I was junior. I refused and I said, the reason why I'm in this court is for me to write. And I wrote the judgment, and the judgment was marked not reportable, even though I thought it should have been reportable, but the panel said, it's not reportable. I accept it. And lo and behold, the judgment found its way in the hands of the academics. I think Professor Slema, in the last interviews, asked me why I did not make it reportable, and I told her that it was not my choice. And she said she liked the judgment and she was going to prescribe it to her law students. So that is another contribution that I made to the law students, arising from my insistence to write the judgment. And I want to say again to Professor Slema, thank you for that. CJ, I wrote many judgments at the SCA. I also wrote on tax. I wrote on IP. I sat in panels. I sat in panels where we did customary law. I think about 4 or 5 cases. Ludidi, Mpepu, and the late Mama Winnie Mandela's matter, and the criminal matter of Inkosi Abatembu Dalinyebo. So my experience is diverse. My experience, I would regard myself as a versatile lawyer. I wrote another judgment at the SCA with insolvency practitioners, and it went to the Concord. The judgment was confirmed. The majority judgment written by Brother Jafta and Justice Madlanga writing the minority judgment. And CJ, there's a judgment that I wrote again at the SCA dealing with the K word, and which I found it offensive and not having a place in our modern society. Again, CJ, I don't think you knew me then. You had occasion to write a judgment, and then on a particular topic, similar topic rather, and you then quoted me authoritatively, and I must thank you for that. A reference to one's judgment by a higher court strengthens one's ability and one's relevance in the legal fraternity. CJ,
I take it you are done now, or you are rounding up?
I'm not done, CJ.
Okay, just try and round up.
I'm coming to the Concord. CJ, at the Constitutional Court, it is different from the SCA. We don't have seniorities and everybody is more equal. Your top 6 doesn't exist. There is nothing like that. It's a comfortable space to stretch one's leg and write. And if you've read the book of Steve Bantu Biko, you write what you like. And I was able to write and freely, not to say I could not write freely at the SCA. I wrote the seminal judgment that I wrote, CJ State versus Chabalala, I had to do a lot of research, check so many case laws or case authorities, and to come to the conclusion that common law or common purpose does apply to the common law crime of rape. That judgment really affirmed our society, CJ. And if you'd remember, CJ, we almost missed that opportunity. And in my post-hearing note, I said we have jurisdiction. We should deal with this case head on. And I'm glad the majority or all the justices agreed with me and gave me the opportunity to write that judgment. And it's a good judgment, I must say, if I were to praise myself. Yeah, and I wrote also on other aspects of the law, on labor law, on admin law, everything. CJ, you gave me that opportunity to write, and I thank you. Over and above that, CJ, my other extra judicial duties. I am passionately a trainer in the School of Excellence at Sajay. I train, mentor aspirant judges, permanent judges. One would ask, where do you get the time? I have all the time to do it. And I've, in one of the sittings, just not to be long, I put up a team of the trainers who were women only. The reason being simply that I sit with women colleagues on the bench, and I don't see any reason why they could not or they cannot be the one imparting the knowledge and the experience on other aspirant judges. And now recently, CJ, as in 2 weeks ago, I also coordinated a course through the request by JP Mlambo for exclusively or only women lawyers. We had about 35 of them, and then we ran that course, and I think the majority of those women would be acting in various courts in the country. And we took them through on judgment writing, motion court, criminal, civil, and everything. We also gave them assignments. And once you give them assignments to write judgments, you also, as the facilitator or representer, you learn the trades from other people. And the reason why I did that, CJ, is the realization that our women are marginalized, our women are left behind. So it is important that we should emphasize and help them. When I look back, I can simply say, CJ, in conclusion, that in all the courts, I have candidates who have come through Sajay and their judges. I take comfort in the fact that I can say my seats are growing on other people's trees. Thank you, CJ.
Thank you, Justice Mathopo. Colleagues, may I have a list of those who would like to put questions to Justice Mathopo, please?
Makwanisha,
Muimang,
Lamola,
Lucas,
Nyambi,
Ofu,
Please, sorry. Yes, after Honorable Nyambi, who's next?
just me, CJ.
Okay.
And
Judge President.
After Honorable Singh, who is it?
Schlemmer.
Deputy.
Oh, okay. And after Prof, who is it?
Did you hear Dodovu?
And
Tepe.
okay. Any other colleague?
Chief Justice, do you have Petse after Tsepe?
Okay, DP. You know, I sometimes make a mistake instead of saying DP, that's I say DP Tsepe. Maybe I'm prophesying. After Deputy President Petse, who is next?
Did you hear Lamula CJ?
Yes, Minister, I've got you right here.
Thank you.
And CJ Jenny Kane, please. If you could please add me at some point. Thank you.
Is that Advocate Kane? Is there anybody after you?
Yes.
Who comes after Advocate Kane?
No.
Did you get my name? Chief Justice Breitenbach?
I've got you, Honorable Breitenbach. You're right here. You are number 4.
JP
Just put me right after Bredenbach.
When I always want to be right after Breitenbach.
Wait a minute. Oh, Honorable Malema. Okay, you're
No, I'm joking, CJ, I'm fine.
Oh, you don't want to be included?
Chief Justice, can I just, Matonsela here, can you just record that I don't have any question for this witness?
What about Honorable Malema? Should I include you?
No, I'm
Honorable
fine. I'm
Malema?
fine, CJ. I'm fine.
Okay. All right. Okay.
Do you have my name,
All right.
CJ?
Sorry.
JP Mlambo.
I've got you, JP.
Thank you.
Okay. Honorable Maganisha.
Thank you very much, CJ. Good morning, Judge Mathopo.
Good morning, Commissioner.
Thank you very much. Now, I have 3 quick questions, but I will start by 2, 3, yeah. But I will start by making an observation. I thought you were making a farewell speech as I was listening to you. It was more like a farewell speech, and this is what I've done, so I'm leaving you now. And I hope that is not the case. Let's start with the young Stephen Mathopo then. Ramaka. Let's start with the young Ramaka Mathopo. Very bright student from the University of the North. 4 distinctions in BPROC. I know that you said that you had to take care of the family, but with those good marks, after you were in practice, why didn't you proceed to LLB and postgraduate studies? First one.
Commissioner, I indicated that I come from a large family, and to be specific, I'm one of the 11. And everything that the family put together, they put together for my education. And you would know if you were exposed to the same hardship that I had, that there is nothing like black tax. It's your responsibility to ensure or make sure that your siblings attain more or less the same level of education that you have. Everything that I had, I plow it back to them. And I'm proud to say to you that I was able to put through university almost half of my siblings. And then with the meager amount that I had in practice, I did not want to be that selfish brother who was more interested in his personal advancement. And remember, you are an attorney, people assume that you have the money, and you don't. And you have extended families, your nieces and nephews, they also look up to you to put them through to university or schooling. I had to take some of them, right, the nieces. And I can proudly say to the commission now that I have 2 nieces that have just recently completed their LLBs, and I'm helping them to look for articles. And I had a brother who became a lawyer, sons and stuff like that. So yes, I could have, but circumstances were such that I could not. But what I did was, I am not going to be a mediocre lawyer because I did not have an LLB. I capacitated myself and I know more law than most. And I know more cases than most.
Thank you very much, Judge Mathopo. There is this colonial language that is being used, and I think sometimes it is part of the problems. You see, in Parliament, whether you have 20 years or you have just 2 months, you are just a member of Parliament. But in the profession, there is this strong emphasis on juniors, junior judges, junior counsels. What is your view on that? Tying it up with your experiences in the Supreme Court of Appeal.
I agree with you. It's an antiquated system of hierarchy that we found in the legal profession. Mr. Madonzela is silk, and Bofu is silk, and because they're silk, they've earned their stripes to be called silk. So that is where this hierarchy comes from. And when you get to the bench, because of your many years of experience at the bench, and then we loosely refer you as our senior, and it's a leadership recognition in one way or the other. And in actual fact, there is nothing wrong with it. The only thing that is wrong is when the leaders or your seniors abuse their position.
CJ, through you, just the last one. A lot of reference has been made yesterday and today to the top 6 in the SCA. Quite clearly, you would say some of the things that are attributed to those judges, it shows that they have not imbibed the spirit of the constitutional dispensation in them. Why should ordinary people expect that they will get justice from such people? Especially from judgments coming from, I would not say only the SCA. I think there are some courts that they might have such tendencies. As a layman, why should I expect that I would be given justice by people who display such tendencies?
I think I need to put one aspect to rest. Yes, we had the top 6 at the SCA. Things have changed drastically or dramatically in such a way that the top 6, or those who used to be part of the top 6, through natural attrition, are leaving the court. We are no longer going to have that top 6. And where I am sitting, I would also be part of the new top 6. And I have learned from the old top 6 not to do what they did to the others. So I need to put your mind at ease that animal called top 6, we have exorcised that spirit. We will no longer have. DP Pedza is number 2 now. President Maya is number 1. So in the top 6 that we have now, I think 2 members of the top 6 come the end of the year or early next year would be gone. And the court would now be in our hands. If we fail it, we would have dropped the ball in our hands. So we can't afford to do that.
Thank you, Chief Justice. I think when we deliberate, we might want to take the matter further, because I do believe that they are representing a world outlook. Those might be gone, but I don't think the tendency will just disappear like that. But I think when we deliberate, we might want to revisit that.
Thank you, Honorable Magwanesha. Honorable Moiman.
Ke a leboga, CJ. Good morning, Justice Mathopo.
Good morning. Good morning.
If I may have Mathopo.
Mathopo. No,
Mathopo.
ke a leboga, CJ.
Thank you.
In your profile, I see one of your judgment is the Democratic Alliance against the acting National Director of Public Prosecution, where you found that it was desirable that the transcript be produced to test and properly contextualize whether the decision of the ANDPP was based on rational ground or not. Surely from where we come from, the ruling party, definitely this decision put us in it placed us in a conundrum. And I think you'll appreciate that following that decision, the Supreme Court of Appeal found ultimately that there was no connection between the recording of McCarthy and the decision of the ANDPP. Was that decision to test the rationality, to put the rationality to test, was it informed by what the CJ in one of his judgments said? He said that it is important that public office bearers must ensure that they act within the confines of the Constitution, and that this is so because constitutionalism, accountability, and the rule of law form a sharp and mighty sword that stands ready to chop the ugly head of impunity of its stiffened neck. And Justice Madlala also in 2008 said, there are certain foundational values, transparency, accountability, and rationality that must always inform the decision that we take. So, given the need to educate not only ourselves but also the public, do you think that there is a room to improve the role that the courts can play in terms of promoting good governance, particularly the rule of law, without necessarily blurring the line between the three arms of state? Thank you, Chief Justice. Thank you, Justice Mathopo.
Thank you, Honorable Moeman. Justice, over to you.
I am not sure if you want me to traverse the judgment itself,
Yes.
and if so, just a bit of background on the judgment, which I want to believe you're fair with it. When the matter came before me, it came against the backdrop of what had happened before the SCA. And there was a dispute about what that order provided. And it's a judgment of the SCA by Justice Nafsa. And when it came before me, the office of the NDPP or ANDPP elected not to file an affidavit, nor anything, right? Then before the proceedings started, I called the counsel to my chambers and asked whether there was anything that I may have missed in terms of the papers in the court file. Counsel for the NDPP and former President Jacob Zuma said they have elected to take a low point, which they were fully entitled to. And my question in court was, if the low point is not good, are you prepared to lie on that bed or fall on your sword? And they agreed. And it was just whether the tapes should be released to see what was happening between McCarthy and his Bulelani Nguka and his officials at the Scorpions, as it then was. And remember, it was then against the backdrop that there had been some illicit interceptions of conversations, and that those conversations would assist in the prosecution or dropping of the prosecution of the former president, and like your abuse of power and everything. The DPP, Mokotedi Mshe, had withdrawn the charges, and the DA took the matter up. So when it came before me, I had to assess whether that decision was rational or not. And I wrote a judgment. And that judgment was a culmination of other judgments that led to where we are now in South Africa. And you would ask me whether it was right, or whether there was an encroachment on other arms of government. I would regrettably say no. And to answer your question, it is important that a proper and clear distinction must be drawn between through arms of government because of separation of powers. One arm of government should not be seen to be encroaching on the other arm of government, because then courts cannot be allowed to start legislating. That's what we always are reminding ourselves each time you are encountering problems of a similar nature, to say, is this judicial overreach or not? So it's a very, very thin line. And sometimes in other judgments, you would see that the lines have been blurred, the lines have been crossed. And then fortunately, we have, and law is self-correcting. We have an appellate structure where I may have erred by crossing the line. An appellate structure would say, no. I wonder if I've answered your question.
Thank you, Justice Mathopo. Thank you, CJ.
Thank you, Honorable Moeman. Honorable Minister.
Yeah, thank you very much, CJ, and good morning, Judge Mathopo.
Morning, Minister.
I was touched by your story of paying for your siblings, because I'm also a product of the same arrangement. My fees were paid at the university by my sister. So it leads to one Shangani idiom that says that vana va munhu va tsemelana nhloko ya njiya. I'm not sure in Sipedi it's also there. I've heard it's
Bana
also
ba
there.
motho ba ngwathelana tlhogo ya njiya.
Yeah. So I was touched by that, Judge.
Thank you.
My question firstly is on the judgment that you made on the Minister of Justice and Constitutional Development and other versus the South African Restructuring and Insolvency Practitioners Association. For the benefit of the commissioners, this case dealt with the challenge to the constitutionality of a policy to regulate the appointment of insolvency practitioners, which had the objective of promoting fairness, transparency, and the achievement of equality for persons previously disadvantaged by unfair discrimination. And you found that this was unconstitutional because of it was not in line with the court judgment on the court system. And I want to believe that because you are, from your background, I can see that you are a practicing attorney. So you are at pains for sure to pen this judgment, because of your history as an attorney, you understood that the fact that there must be some kind of transformation amongst the insolvency practitioners. So my question is that at the time when you made the judgment, didn't you deem it fit maybe to put some kind of measures or remedy or some kind of creative remedy so that the department is left with something that it could implement in the meantime while it is developing policy? I'm asking this because to date we are still struggling to come up with the policy since the judgment was made, because the court system, as you have pronounced correctly, there are difficulties. The other difficulty that we are trying to revert back to is the issue of the rotational system. It also presents its own challenges. So my question is that at the time when you made this ruling, didn't you think that it might be in the interest of promoting black practitioners in the insolvency space to put some kind of a remedy while the department is given an opportunity to find a suitable solution to this quagmire?
Thank you, Mr. Minister. One has to be mindful of the fact that, as Commissioner Muimang has alluded to, not to legislate. Number one. Two, at the background of that judgment, you had that quota system. Three, you talk about the lived realities of the practitioners, especially the insolvency practitioners. When you read that judgment, you would notice that the policy that was in place sought to advantage your previously advantaged practitioners and sought also to have a condescending measure, in the sense that they would say, insolvency practitioner Lamola would twin with Mrs. van der Merwe. And one may say that is empowerment. It is not, because you become that junior perpetually and there is no room and for you to grow. I think when I wrote that judgment, the realization was the time has now come for our people to be accorded equal status in the country of their own. The fact that you find yourself unable at this stage to put measures in place to deal with it, I would strongly urge you, Mr. Minister, to make sure that those practitioners that I know very well, they should be accorded their space. I could not do anything because of being shackled by the principle of stare decisis in terms of the quota system, as in the Van Heerden case. And the CC, alive to the problems that I had dealt with and faced in the judgment, also could not, in its wisdom, put measures that you are bemoaning the fact that should have been put in place. And I think the reason is simple. Both myself and the judgment in the CC by JAFTA took the point that this policy is rational. Does it serve any legitimate purpose? And when we found that it does not serve any legitimate purpose, you don't fix it, the problem, one by one. I would urge you, and I would also urge the insolvency practitioners to take up the cudgels and reform and reformulate this industry.
Yeah, no, thank you, Judge. You may not be aware, but we have recently appointed the first black chief master in the history of this country since democracy. What could you advise him on the basis of you having dealt with this matter to resolve this issue of transforming the insolvency space for the benefit of black practitioners in a manner that will be rational, will not be condensing, but will be to the benefit of the country as a whole? Because if black practitioners are given space to come into this industry, they will also be able to understand the operations of the economy, the insolvency world, and all that is, so with the benefit of you having sat on this matter, what could you want to advise the Chief Master?
Minister, the advice is simple. We should not be apologetic about what is rightfully ours. We should not be apologetic about the fact that we have been marginalized for far too long. What the Chief Master must do, have a meeting of all the practitioners across the broad spectrum. Sit down with them, have a policy in line with the two judgments, and critically look at the judgment and say, in what way can we make it possible that all the practitioners can operate in a space that is less objectionable, nor discriminatory? We should take up the fight. I would say to the Chief Master, you can have your boss barat, your road shows and everything else. You hear, you give the Chief Master that necessary support.
Thank you, Judge, and thank you, CJ.
Thank you, Minister. Honorable Breitenbach.
Thank you very much, Chief Justice. Good morning, Judge Mathopo.
Hey, good morning. Good morning. How are you?
Very well, thank you, sir. How are you? You'll understand that Democratic Alliance was particularly delighted with your judgment.
I know.
In that matter, yes, and as an ex-prosecutor, I was particularly delighted with your judgment in the Shabalala matter.
Oh, thanks.
There can be no logical reason why, with respect, that the doctrine of common purpose shouldn't extend to the Commonwealth Crime of Rape. So I think that's a wonderful development. I've listened carefully to how you have set out your support for previously disadvantaged practitioners with some admiration, but with more admiration for your trouble that you've taken with women, which is particularly admirable. I would like to ask you, seeing that you have a lot of experience in many courts, whether it's your view that women practitioners, but more importantly, women judges, are held to a different standard than their male counterparts. I would be interested to hear your views on that. Thank you, sir.
Thank you, Ms. Breitenbach. It's good to see you. You and I had many battles down there in the prosecution. And,
indeed.
And you would remember our skirmishes and the battles that we had. And at no stage did I ever think that you are less competent than most of the women. And you were a fierce and a formidable opponent then. And I think you still are in your own little space and wherever you are. I believe quite strongly, and this is a belief that I shared in all the walks of my life, that women have a right to be in the space in the same way as men. It would be a travesty of justice if we were to relegate women, as I said in Shabalala, to second-class citizens. On the bench, I have mentored a lot of women. I have interacted with a lot of women. There is something different that women bring to the bench. Men may have that rush of adrenaline. Women are able to sit back, listen, and afford litigants a hearing quite properly. If I were to fly back to the SCA, if you have Justice Maya presiding, and you know that the hearings would be filled with some warmth and would be filled with some deference to counsel and respect. So women indeed do play a major role in the transformation of our judiciary. I hope I have answered your question, and if you need clarification, I'm ready to do that.
I'm fine. Thank you very much, sir. Thank you.
Honorable Nyambi.
Thanks, CJ. Morning, Judge Mathopo.
Morning, Commissioner.
In the case of the Congress of the People and another COPE versus Shilowa and others 2012, the diligence and the promptitude that you display hearing an urgent matter late afternoon on Friday delivered a well-reasoned judgment on Sunday afternoon. This judgment was confirmed by the SCA on appeal. How important it is for judgment to be delivered promptly and timeously?
Thank you, Commissioner. The background to that judgment is I took over the urgent court on a Friday after 4. And that weekend, one of my sister was getting married. And as the eldest brother, and you know, in terms of the African tradition, I had to go around looking for the goat or the sheep to slaughter and make sure that everybody is there. And when I think at that time, that was when the urgent court in Johannesburg was allocated to one judge. So I could not pass the buck or ask anybody to do it. Those duties fell on me. And COPE then, as you'd recall, it was more of a breakaway from the ANC. And before hearing that matter, just to give that background, I spoke to the council on either side to see whether they can find a way with each other, the two warring factions. And it's a missed opportunity, I must tell you. They could have taken my counsel. They did not. I had that application on Friday afternoon. And as you would appreciate, while doing those negotiations and preparations, the judgment was always at the back of my mind. And it was so urgent, it came in the urgent court. So I had to work at night and make sure that Sunday I deliver a well-reasoned judgment. And it is important that judgments, to the extent possible, be delivered promptly. You do that because you want people to be able to regularize their affairs. A long, outstanding and delayed judgment suspend the people or their affairs. So that's why I had to deliver it as quickly as possible. It is important. Let's not delay. One you would say justice delayed is justice denied. You can well imagine if I had reserved judgment, what would have happened? You have two bulls in one kraal fighting for the soul of the leadership of COPE. So I had to resolve it, and I tried them. I implored or nudged them to resolve it, and they could not, and the judgment came. And COPE lost its hope to live.
Is what it is. Thank you. My last question. My colleague, Commissioner Malema, will always remind me that in our respective villages, it's always a nice feeling when we see a person that has been appointed by us doing extremely well. So at all times, we must go for merit. And I look at the appointment, or the letter that is coming from BLA talking about you, Judge Mathopo, talking about your attributes, that you have got the respect by the legal fraternity. We are highly motivated, we are dedicated, hardworking, well organized, well spoken, and meticulously prepared for court appearance, independent, reliable, and mentors acting and junior judges. Maybe if you can tell us what is the secret behind these attributes?
Commissioner Nyambi, I schooled in a village called Butogwa in the Mukomeni area.
That's where I married.
I grew up there in my high school life, and I've seen when there how painful it was for all of us to pull ourselves through our bootstraps. I realized it then that when I have the opportunity, I must make sure that the road that I have traveled, it must be a road less traveled. I don't want people to travel the road that I've traveled. I may have survived through the grace of God, and I don't know whether other people will. So I took it upon myself to make sure that I train, I mentor from law students through the auspices of the BLA, Law Society, everything. When I started, I didn't have that opportunity, and most people did not have that opportunity. But because I'm in a privileged position, I should not kick the ladder. What other people do once they climb the ladder, they don't kick it because you'll pick it up and go up. They lift the ladder up and go up the roof with the ladder, and then you will never know how they got up there. So I realized I should not be that person. Be there, be involved. One other thing that I would tell you, or tell the commission, is even when I'm acting at the Concord, right, I still induct judges at the SCA. I still induct judges at the High Courts. I still prepare judges for these interviews. And while preparing for my interview, many judges approach me to prepare them for the interviews that we'll be having in subsequent days. I did not say, wait, I've got my interview to prepare. I put that aside and prepare. And to prepare somebody for an interview takes 2 hours max. To induct somebody takes 2 hours max. So this is the time that I've been given, and this is the time that I think I should share with everybody.
Thank you. Continue doing good for the country and the judiciary. Thank you, CJ. Thank you, Judge Mathopo.
Thank you.
Thank you, Honorable Nyambi. Commissioner Mpofu?
Thank you, Chief Justice. Good morning, Justice Mathopo.
Morning.
Well, I couldn't resist this opportunity because you always ask me difficult questions in the Concord. So it's my turn now. I'm in charge. So, CJ, always ask us not to do preambles, but I thought, CJ, with your permission, I just wanted to put some perspective. I'm always talking here, these commissioners know one of my passions is this issue of briefing patterns and when it's not happening. So I think also when it has happened, I need to talk. I just wanted to take you back, 25 years ago, when you and I did the matter of Holomisa versus Argus newspapers. And Chief Justice, the point I really want to make is that, if you say you gave a brief to Advocate Mpofu, people might be thinking about Advocate Mpofu of 25 years later. But then we were talking about someone who was 3 years at the bar. First time my name ever appeared in the law reports was in that case. It was, as you say, a very significant case. And what most people don't know is that my opponent was Gilbert Marcus, who had been my mentor. When you go to do pupillage, you get a mentor, someone, those days, actually it was called a master. So you can imagine how terrified I was getting into that courtroom. And that's what I want you to explain, the value of empowering a person at that level and creating that opportunity. You've made many examples of what you've done in the context of training judges, training aspirant women judges, and so on. But that it's not about money. In fact, I don't think our client, General Holomisa, even paid us. So wherever he is, I think he still owes us. But we must go and collect our money from him. So it's not about money. It's about trusting somebody with that breakthrough, and then obviously after that they have to fly on their own. How would you say we should entrench that so that it's not a Mathopo who takes a leap of faith on a particular person, but that there is a system, and we've been talking to the minister about that, a system whereby those breakthroughs are actually regularized and normalized, particularly at the behest of the state.
Thank you, Commissioner Mpofu. I think it takes self-belief. If you're lacking self-belief, it will be difficult to believe that Minister Lamula would competently do the work. I mean, there were doomsayers when minister was appointed to the portfolio that he's in, that he won't make it. Look at him now. So whoever has that self-belief, and then you inculcate that self-belief and transform it into the realities, you would be able to say, yes, I have belief and faith that this person will make it. Now, when you look at the briefing patterns, it's a sore point that despite the noble efforts that the minister has put in place, remember, government is the largest consumer or the biggest consumer of legal services. We should not be having this debate. We've had this debate 25 years ago, and it is wrong and remiss of us to be still having this debate. While I was at the Joburg High Court, I sat mostly in motion court. And I would see junior counsel moving applications and like substituted service. And you can see there is nothing to it. And their white counterparts would be having a whole stack of files. And then what I would do, I would then call the state attorney down the road to say, my observation in court left a sour taste in my mouth. what are you doing to ensure that work is transferred to everybody? And you see, women council, there is this stereotype that white women council must do matrimonial work. And I mean, to say the least, this is nothing else but nonsensical. They are more equally competent to do the work that their male counterparts are doing. I mean, to castigate you a bit, this is even at the bar, there is that pigeonholing of women. Now, coming back to the briefing patterns, Minister, I'm happy that you have appointed a Solicitor General, but let's not have a figurehead. Let's have somebody that would ensure that the work gets translated. And the translation must not be, you just give me work and go and do applications to compare. There should be value in the work. And sometimes the state attorney would say, I've briefed so many, but there is no value in the work. Let's have value. And there should be a rule, if it was possible, to say, for every senior brief, it must be compulsory that we must have a women or a previously disadvantaged council. It hits across the board, black, white, female, Indians, and everything. They're all suffering, and we can't allow it. I think the time has come.
Thank you. Just to say a matter of clarity, when you are talking about the top 6, because both you and the Deputy President Pets are judges, so you are not able to speak in public, so we have to speak for you. I think there's a potential misunderstanding when you mention the name of Deputy President Pets. As an example, someone sent me a message saying, is he saying Deputy President Pets is the king of the top 6? But I think you clarified that what you meant by the top 6 in terms of seniority and what you call the new top 6, the good top 6, so to speak, and the one that is fading away by natural attrition. So I thought maybe you might want to clarify that example.
No, but the reality is part of the top 6, the new top 6.
Yeah, the good top 6. Okay.
Yeah.
Thank you. Yeah, I didn't want to be sitting here next to the other top 6. All right. Then in terms of just going back to the case that you and I did, but now more on the technical side, some of the principles that we established in that case, which were now these days are taken as common cause, such as the horizontal application of the Bill of Rights, and the fact that at least for our media colleagues who are here, it established the principle that the media in the space of political activity could publish false information about the person, as long as that was reasonably done. As I say, those are principles that have now become almost trite, but there's still a debate which you and I started in that case, which has not been resolved, around the paramountcy of freedom of expression, which is clearly an important constitutional value on the one hand, weighed against the value of human dignity of the person who's being defamed, which must also be protected. As you know, human dignity was proclaimed in the case of Makwanyana, the death penalty case, as one of the most paramount rights, second only to the right to life in the context of apartheid, because apartheid by definition was the denial of human dignity of people. and we argued this forcefully in that matter. Where are you on that debate? Because then I know where you were. Then you were with me. But as far as the current dynamics in South Africa, as between weighing those two very important rights, do you think that contestation has been resolved, will be resolved? Looks like it's better resolved than it was 25 years ago.
Thank you, Commissioner Mpofu. Subsequent to that judgment, I had occasion to pen another judgment while I was acting, and where I partly dealt with that contestation. It's a judgment in SA taxi securitization versus Media 24. Just a bit of anecdote. When that matter was allocated to me, I'm told that the council bemoaned the fact that why this case was allocated to an attorney, Nohale Jr., and blah, 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 all sorts of epithets. And very soon when we started the hearing, they realized, much to their sorrow, that they were dealing with somebody who was au fait in that area of the law. The judgment was taken on appeal to the SCA. The court was split. I was partially upheld and partially set aside. That debate has not been fully resolved. As a lawyer, one would say you're waiting for a proper case that could be taken further up to the CC, where you could deal with that aspect of the law and try and do a collation of other cases, Ohoshi, Dlomo, and all other cases, and distill out of that cases the role of the media, the role of publication, the falsehoods and the truthhoods of that. So we still are there.
Thank you, Chief Justice. I just in parting want to say that your judgment on the K word, which the Chief Justice quoted, was a very good contribution to our jurisprudence, and it made us to win the Brackenfell case a few months ago. Thank you very much for that. There are very few people who are prepared to confront issues such as the K word frontally, as it was done in your judgment and that of the Chief Justice. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner Mpofu. Honorable Singh.
Thank you very much, Chief Justice, and good morning, Judge Mathopo, and
morning.
To all the commissioners that are there. The issue, Chief Justice, of the top 6 still haunts me and bothers me. And I've heard it many times before sitting on this commission. And I think Commissioner Magwanisha is right, that we need to have a very honest discussion about this top 6. Now, Judge Mathopo, you did mention that the top 6 is changing its character. So it's going to be there for some time to come, although with different players. And you did also say that some of the players will be leaving at the end of this year or thereabouts. Now, what is your view on the idea that we should have a full investigation on the existence of the top 6, its influence, whether undue or not, on the judicial system, so that South Africans can have comfort that even at that level of the judiciary, there is some level of collegiality and that jurisprudence is the winner. You did also mention the influence of the media. Now, I would not think that all media houses will not want to take up the matter of digging deeper into the existence and the influence of the top 6. There certainly would be media houses that would want to give different views and report differently to the public. What would your view be on this issue? Thank you.
Commissioner Singh, if there is a person better suited to talk about the top 6, it's me. I would do that not purely to protect, nor to unduly expose it. Perhaps to put matters in their proper perspective. What would normally happen at the SCA, which would lead to this unnecessary and unpleasant incidences, is that one would refer it or label it as judicial intolerance. I have, together with some of the colleagues, confronted the issue, and then we have succeeded in exorcising that ghost. But I cannot say to you that entirely it's gone. People's personalities are there. It happens that some colleagues would take unnecessary liberties and overexert their authority, especially on junior colleagues. To the extent that I have been aware of that, I have taken it upon myself to speak to the victim and to speak also to the colleagues concerned, to raise it with them that this behavior, it's despicable, it must stop. Whether the full-blown inquiry would help or not, I would say no, it won't. For the simple reason that we had our sensitivity or diversity meeting where we laid it upon the possible top 6 and impressed and prevail upon them that this particular type of conduct should not be countenanced and should stop. And I've kept tabs at the SCA or with the SCA, and I've been reliably informed that this has not happened. The meeting that we have was in 2019, and I have been away because I've been at the Constitutional Court for almost 2 years acting. So, but Justice Pesa will confirm it that things have now taken shape for the better. And I don't think we still have those wounds, but that we must revisit and scratch the wounds. But there would be. I cannot say that the incidences are gone and there would not be any isolated incidents. There will be. It's natural. There will be, Commissioner Singh. And I would not, I don't want to sit here and vouch and say it will never happen. You may be told that when the SCA is interviewed that it has happened. And I don't want to be seen to be a person that lied to the commission. I make that disclaimer. Thank you.
No, thank you, Judge Mathopo. I think it's helpful to know that you are willing to stick your neck out and cooperate in any kind of inquiry that may come about with regard to the top 6. My second question, Chief Justice, to you, Honorable Judge, is yesterday we spent a lot of time on dissenting judgments. And I think since you've been acting at the Constitutional Court, you are aware of dissenting judgments or minority judgments. What is your view on minority judgments right at the level of the Constitutional Court? And I'm saying this having due regard to your independence, to your thinking, to you not allowing anybody to trample on your toes, etc., which you said right at the beginning. Thank you.
I think it must be emphasized why and when do we have dissenting judgments. A colleague may not see the issues the same way as you see them. And at the Constitutional Court, what normally happens is, after the hearing, the scribe would send out what is called a post-hearing note. That is, in other words, how you see the case. And colleagues would comment on your post-hearing note. And some would agree or some would not agree. And when they don't agree, you can't be engaging them also on the post-hearing notes. Then that's where you have to sit back and write your judgment in such a way that you persuade them, or that is, you write forcefully to persuade those who did not see the issues the same as you see them. And if you are able to convince them, they will come over and concur in your judgment. But if colleagues still, and notwithstanding that, see and approach the issues differently, I think it is their right. We cannot muffle or muzzle the colleagues from expressing what they think the case should be decided, or how the case should be decided. Nothing wrong with dissenting judgments. It happens everywhere. Well, there is a famous saying that your dissent today may be law tomorrow. And you would want to know, why is it necessary that a colleague at the level of the Constitutional Court would write a dissenting? The answer is simply, why not? But what happens is, there is what we call do-nathering. Try and come together and see how far are we far apart, and what can we do to come together, and if need be, speak with one voice. You would have those meetings, you would have those do-natherings. And if still colleagues see the issues differently, there is absolutely nothing you can do. But there is serious engagement preceding delivery of the judgment. So that is how and why you sometimes see what you'd call dissenting judgments.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Singh. Professor Schlemmer.
Thank you, Chief Justice. Good morning, Justice.
Morning, Prof.
It's nice to see you again.
Thank you.
I wondered whether you would recall our interactions the previous time.
I do.
Quite a number of years ago. The case of Pfeiffer versus Van Wyk, I do indeed prescribe to my students, not only because it clarified a particular principle of law, but also because we don't really agree with some of the other things that you said in the judgment, but that is what academic discourse is all about. And what I would like to hear from you is, you referred also to reasoned judgment and the importance of that, the scholarliness of judgments. What is your take on that? To what extent, especially in an uncodified system that we have, what role does scholarly judgments play?
I think all judgments are scholarly. Otherwise, if I were to give a judgment that is not scholarly, I would not deliver it. And when you write your judgment, the immediate audience is the litigants before you. And but you don't have to write it thinking about the litigants only, because your judgment may have an influence on other sectors of society and community. So then it is important that your judgments, to use your words, be as scholarly. I would perhaps put it this way: be as best as possible, and then you have to make sure that all the issues are properly narrated, properly researched. Remember, like you have made reference in the judgment that I have delivered, it is probably prescribed, not for the reason that I thought it is, maybe for the reason that to say, look at the judgment, it is not as scholarly written as it should be. And then the do's and don'ts. So one has to be careful. And when you write the judgment, to say it can be used somewhere, it can be used at another instance. I wrote a judgment while I was at the High Court in Johannesburg. And my son was studying law at UJ. And then he came with an assignment, and the assignment was based on the judgment that I had written. So it is important that whatever you write, you must be mindful of the fact that it could land elsewhere where it could be used. So it is important. I agree with you that the judgment should be scholarly.
Thank you, sir. Thank you, CJ.
Thank you, Prof. Honorable Dodovu.
Thank you very much, CJ. Good morning, Justice.
Morning.
I want to forego my opportunity to ask you questions because of two reasons. One is that I'm largely covered by the colleagues, but secondly is because of the interest of time. It's because of that. But just my point, I fervently appreciate what I hear this morning, and I'm learning a lot. And just moving forward, I think that just listening to you and looking at you, I appreciate your demeanor and your voice. But that is just between the two of us. Thanks.
Thank you.
Commissioner Tsepe.
Good morning, CJ, and thank you. Good morning, Judge.
Morning, Commissioner.
Judge, first I would like to commend you for the work that you're doing in training young lawyers in judicial skills, especially women lawyers. It is an important task for the transformation of the judiciary. And I think we should commend you for that work. What I wanted to ask you, the first question is, in this task, are you roping in other judges so that they can take over from you later, and mainly women judges in this role? That's my first question.
Thank you, Commissioner Tsepe. I did mention that I had a whole team of women facilitators or trainers. And now recently, when I coordinated a course for women lawyers, women judges, we had about 6 to 7 women who were presenting, and the men were just 3 or 4. Yes, I am mindful of the fact that at some point or the other, I have to pass the baton. The baton that that was passed on to me, it was passed by Justice Majid. He said he has run his race and gave me the baton, and those were big shoes to fill, and I had to make sure that I don't fail him. Thank you.
Thank you. The second question I wanted to ask you relates to when the CJ gave you bragging rights. You spoke extensively about your exposure as a judge in a diverse area of law, including commercial law, tax law, customs and excise. I wanted to find out from you, do you think the Commission should view your expertise or exposure in this area as a distinct advantage in considering your application to the Constitutional Court?
I think it is, and I have to make that concession. I think it is, and I have been privileged in the sense that I have been given the opportunity. Remember, in life, there's one thing that we need. We just need an opportunity. I've been given the opportunity to write extensively about everything. And I've sought out work on the bench that I be allocated to write on virtually and almost everything. I've written on contracts, everything. My experience it's diverse. And if you were to ask me to describe myself, I would say I'm a versatile lawyer.
Thank you, CJ.
Thank you, Commissioner Tsepe. Deputy President Pitse.
Thank you very much, Chief Justice. Good morning to you, Justice Ramaka Stephen Mathopo.
Morning, DP.
I've noticed that almost every commissioner who spoke before me prefaced their question with an observation. So I'm not going to step out of that tradition. I'll do likewise. And the observation that I want to make relates to, should I call it the much maligned top 6? You know, I'm looking at the list of judges of the SCA for the 3rd term, and I see that when you return to the SCA after your long leave, you'll be at the doorstep of the top 6 territory. Perhaps you might want to, to comment on that if you wish to, and whether you are looking forward to being admitted into that league. Then going into serious business, I'm not going to dwell on your virtues as a judge. I think your record speaks for itself. But I want to deal with you on an entirely different topic. In fact, I want to take you up on the theme alluded to in paragraph 18 it is of the questionnaire. You don't have need to go there. I'll read out for you. It reads, open quote, mindful of the need to create a judiciary that is more representative of the people of South Africa along both race and gender lines, close quote. And if I look at section 174(2) of the Constitution, it provides that the need for the judiciary to reflect broadly, the racial and gender composition of South Africa must be considered when judicial officers are appointed. And I've made a note of the permanent justices of the Constitutional Court at this present time. And what is clear is that there's currently no white justice in that court, be it male or female. There is currently no black justice of Indian extraction, white male or female. And my question to you, do you think that the JSC would be advancing the dictates of and or demonstrating its fidelity to the constitutional command in section 174(2) if it were to recommend you for appointment at the Constitutional Court, given the candidates that we have at our disposal, offering the JSC an ideal opportunity to give effect to section 174(2) that the commission is enjoined to do. Thank you.
Well, if I start with your top six, I think we have belabored that point. And yes, you are the DP, you would know whether I stand at the door of the top six. But I think one myth must be demystified. The issue about the top six, even the top six themselves, never referred or described themselves as top six. I think in all fairness to them, that point has to be made very clear. It is through no fault of their own that they happen to find themselves in the top six. And it would happen to me as well, that I would, through no fault of my own, find myself in the top six. I think the issue, whether there is top six or not, for it to be resolved, it requires the leadership of that court no longer to be categorizing judges in terms of their seniority to a point where you have number one, number six, number what. At the Constitutional Court, when I acted there for the better part of my almost 2 years, I never got a distinct feeling that there were some judges who were more senior than the others. That artificial distinction has long been buried or was never there. So, and I think the leadership at the court should take it upon themselves to ensure that we no longer have it. And once you can put that to rest, we will not have this. I would not even say I would be a top six candidate in a year or two. So I think we need to do that. Coming to matters of substance. When I read section 174(2), my understanding and the text of it does not make it obligatory that you should consider all other racial groups. The answer is simple. If you take the history of this court, the Constitutional Court, it took about 25 years, maybe 25 years, let me put it that way, before we could have, okay, let me put it this way, before I get there. I think it would be remiss of us to look at the appointments in terms of skin pigmentation. And when you look for a fit and proper person, you're not looking at the color of the skin. We say South Africa belongs to all who live in it, black and white. We should look at judges not in terms of color, but in terms of what they can bring to the court. Now, the reality is, I think for the last coming 25 or 20 to 25 years, we've never heard in that court, if we were to play color, judges of colored descent. And at no stage was it ever raised that because of that, Section 174(2) was violated, because this body was not looking at color. Thank you.
Thank you, Justice Mathopo. But just a follow-up on your suggestion that it might be advisable to do away with this issue of seniority. I'm aware, as everyone knows, that the Constitutional Court sits and bank. So at any given moment, there's just one court running. But with the SCA, that is not so. When we are in Bloemfontein, there are 3 courts running at the same time. And when hearings were conducted virtually, sometimes there were 4 or 5 courts running at the same time. And the seniority in reality determines who take charge of which court. And how, in your view, if you were to do away with that, would we manage that type of situation at a practical level?
Thank you, DP. I think you would recall, and I would have to mention it for the purpose and for the benefit of the commissioners, that I lost the debate twice. In other words, if I didn't get the support of the other colleagues. And the reason, this is my view, and that was my view then. I advanced an argument that says the DP and the president must be the ones that allocate work, scribing duties. I raised that argument, I lost it. I raised it again, I lost it. And the reason why I was advancing that argument is, you saw the presiders, because there was a perception that the presiders would say, I've allocated a judgment to Mathopo. And it seems as if it is his judgment. It's the court's judgment. It is our judgment. And the presider would want to have ownership of that judgment. It cannot be. That pains me up to this day. Because at the Constitutional Court and at the High Court, you don't have those ownership of judgments. Why do we have it? A senior colleague would say, are you writing for me this term? It cannot be. It's not right. So, but if all what the role of the presider should be, just to go into court, marshal the proceeding, and that's it. And ensure that the judgment is sent and collated and coordinated, that is delivered promptly. That's about it. I lost that debate, and I'm, as you can see, I'm passionate about it.
Thank you. Maybe finally, as a follow-up, I don't want to belabor the point at this forum, but I'm extending an invitation to you at our general meeting upon your return to raise this once more and possible give everyone an opportunity to explore, how practicable would that be? Thank you.
Thank you, thank you. I've done it before, and it came, at some point, it came very close to winning it, and something changed. I'll do it.
Was it not because I was against you on that aspect?
It's also a possibility.
Thank you, Judge Mathopo. Thank you very much, Chief Justice.
Thank you, Deputy President. Commissioner Matolo Tepu.
Thank you, CJ, and thank you. Good morning, Judge Mathopo.
Morning, Commissioner.
You know, I know that people, all my fellow commissioners have been speaking about the transformation of the judiciary. And one of whilst they are talking, I'm just thinking, as you know, that the Legal Practice Act, the original intention was to try and fuse the profession, the attorney's profession and the advocate's profession. Unfortunately, we couldn't. We had to settle for the middle ground. But I must say, I'm really proud of you as an attorney, having come this far. And I must actually assure you that you are a shining armor amongst the attorneys. But what I want to find out from you is that how do you see the performance of attorneys in court and the performance of advocates? Because there seems to be this fighting for turf and this seniority, and the other one is better than the other, and the perception that goes out there, as if we didn't go to the same universities and the same courses. And secondly, for me, we seem to have a problem that our advocates don't want to embrace the transformation agenda of the LPC. They still want to hold. I'm not talking about the converted on my right, you know. So they still don't want to embrace that transformation. So my fear is, the more you go up, some of you who are really committed to transformation, we may have the missing middle. And how do you fast track that? We do away with the differentiation between the attorneys and advocates.
Thank you, Commissioner Lebo. Yes. Just a bit of background. When the attorneys were granted the right of audience in the High Court, there was a lot of resistance. And this is the resistance that you are now facing or encountering with the advent of the Legal Practice Act. The other members of our profession do not really want to embrace us. And the irony is, they get briefed by attorneys, but they don't think the attorneys can be their equals. So that's where it escapes me. The attorneys grovels and go and get work and brief them. But when it comes to the right forum, they want to be slightly ahead or above the attorneys. That cannot be right. And you would see that in court. What I would do in court, as in the motion court or in the civil trial, there would be attorneys and as well as advocates. And I would say, before I call, there would be this thing that the matters would call pair seniority. And the advocates would want to precede or call their matters first. I would say, no. Sigogo has been an attorney for so many years. And then Sigogo, go in first. Because the same way that I accord Madonsela or Mpofu the respect, I must accord it to Mr. Sigogo for his long experience as an attorney. So that's what must happen. That is what I inculcated at the Johannesburg High Court, to say, I'm not going to beat about the bush. They have their rightful place in the legal profession. Whether advocates want to embrace us or not, I know we lost the battle in the Legal Practice Act. That is why the idea or the purpose or the reasoning or the thinking behind the Legal Practice Act was to fuse the two professions. But they have dug their heels. They don't want. So this is the problem that we have. But us on the bench, we must make sure that those artificial distinctions are not allowed to perpetuate.
Just a follow-up, Judge Mathopo, do you think we can still move for the fusion of the profession?
I see nothing wrong with it. I see nothing wrong.
Thank you, CJ.
Thank you, Commissioner Mathopo. Advocate Kane.
CJ, if you can indulge me after Advocate K or the last, just I have a follow-up to the judge, but even after Advocate K.
Is that you, Commissioner Nogesi?
Yes, Chief Justice.
Thank you, sir. Thank you so much. You'll come after Judge President Mlambo.
Thank you, Chief Justice.
Okay, sir. Over to you, Advocate Kane.
Thank you, Chief Justice. Good morning, Justice Mathopo.
Morning.
Recall we met for the first time in 2010. At that stage, you were already an established soul on the Gauteng High Court bench, and we did an appeal together when I acted on that bench. What I remember so clearly, and what accords with so many of the answers you've given today, is how you did teach others. And what I learned from you was a very measured, considered, and systematic manner of approaching legal life. You really taught me to look at it as a marathon. In those days, I was a lot more frantic than I am now, so it was a lesson I needed to learn, and I thank you for that.
Thank you.
For the same reasons that have been given by Commissioner Dodovu, I'm happy to say that I am covered, and so in the interest of time, I'll pass over to Justice. But thank you.
Thank you, Advocate Kane. Thank Judge President Mlambo.
Thank you, Chief Justice. Judge Mpof, sorry. Justice Mathopo.
Yes.
I would like you to deal with two issues. One is the appetite of the top six of old to stomaching a dissent from a junior judge, especially one who is acting. I don't want you to tell a story. You can just give an example of a case and leave it there, because just in the interest of time, that's one. Then maybe to help you, I have a number of cases in mind, but one of them is a baboon shooting case, right? But I don't want to tell a story. So that deals with the appetite of the top six then of stomaching a dissenting judgment by a junior member of that bench. That's one. But perhaps the other one, because I just wanted to deal with both. The other one is the elephant in the room about the language that's used by SCA justices when they criticize judgments of High Court judges. And that extends beyond the top six, by the way. So I just want to read for less than a minute. I'll read you a comment, which is before us here, against one candidate, where the SCA was reversing that judge's judgment on review. And this is what it says, what the comment of the scribe of that judgment is. It says, why she did so, or whether she merely overlooked these other grounds, is known only unto her. Further on down the line, the same judge says, her failure to deal with certain of these grounds of review remains a mystery. I'll leave it there. Thank you, Chief Justice.
Thank you, JP. Judge Mathopo.
Thank you, Chief Justice. Can I just start with the language? Because no, let me start with the top 6 and the reluctance to deal with dissent judgments. Yes, JP Mlambo, it was quite evident in the Baboon case that what happened to the judge who saw issues differently was wrong. The conduct of the top members of the top 6 was wrong. What happened in that case, as you would recall, I'll reveal the identity of the scribe once I've made my point.
Please don't reveal the identities.
Okay. Well, they can always find it. State versus Crossley. So what happened in that case is, after the junior judge had written, there was a repost. And the purpose of the repost was to show up that the junior judge lacked a fundamental understanding of how to analyze a simple and tried principle of criminal law, how to evaluate the evidence. And when I read the judgment and I spoke to the judge concerned, and yeah, it was wrong. And that's what should not happen. And up to this day, and I think it's something that should just not be allowed to continue or to happen at all. And when you read that Baboon case, it has its own history and how the case got to be at the SCA at that time. And yeah, maybe I should not say more and stop there. The language, JP, one has to ask oneself the simple question: how would you feel if somebody were to say that your judgment lacks thinking or whatever? I know, to respond to that one, I know of a colleague whose reasoning, a senior colleague, was said to be bewildering. Kaspedia Magacha. And I know of a colleague in Joburg as well, who it was alleged that Justice or Judge X did not apply his mind. And that offended the colleague tremendously, to say, but if a judgment says I did not apply my mind, what does that mean? So it is important to know that when we write the judgments, they are not, as I indicated earlier, they are not for the judge concerned. Posterity will come and harshly deal with us for having written so freely and so wrongly about colleagues. Anything that you describe, like for example, the language that is used here to say it's a mystery. I mean, you could use better and different and more respectable language.
Follow-up question, the small one, CJ, if you permit me.
Yes, JP. Yes, JP.
In your own experience, Acting Justice Mathopo, have you ever found such language in any of the judgments of the Constitutional Court?
Now what? No. I mean, no. No, I've acted for just about, CJ is about 18 months, close to 2 years there. No. And colleagues would tell you that's not the language that we use. Thank you.
Commissioner Nogesi.
Thank you, Chief Justice.
Judge Mathopo, I'm just interested in two questions out of the debate with the deputy judge. Doesn't really matter if in the Constitutional Court all judges there were to be black judges. Would it really matter if in the proper interpretation of 174(2) is that first, I mean, before that, all the judges that come here or candidate were competent, good candidate, appropriately qualified, were black judges. Would it matter if we appoint all of them? Or the president, sorry, we recommend, sorry.
I would not think so.
Finally on this, your interpretation of 1742 doesn't compel this board to start to say, oh no, let's calculate. In the Concord today now, out of 11, we have 2, we have 3, we have 4. I mean, this composition doesn't really compel that, or it simply emphasizes the fact that when you are doing appointment, you must take into account those factors in the process. I just want to.
It is correct. You cannot be starting to playing the numbers game.
Lastly, then, I mean, this is unrelated to this one. It's follow up on the language used in judgments broadly. Did you, in the matter of the public protector, the language used by the Constitutional Court there, egregiously acting outstandingly. I mean, language that was used, the words that are used by the judges in description of what they believe is the actions of the public protector and institution of government. Would you say the language, judges must be careful when they deal with other judges on their language, or it is a matter that when you write a judgment, you must be careful of the language when you describe other public officials, even if it's a minister or is a government, whatever. The question of language is what one should be careful about.
I think I agree with you. If I'll answer that by way of an example of a case. If you would remember, there was, I think I'll give you the judgment. It's NDPP versus Zuma. There's a judgment by Nicholson in Durban. The language that was used there to say he red-carded the players, the officials, and everything else, it was not a language befitting a description of a judge. So one has to guard against at all times the language that you use in reference to your fellow colleagues. They are your colleagues whether you like it or not, or other members of the departments or wherever.
Thank you, Chief Justice.
Thank you, Commissioner Nokesi. Judge Mathopo, now to ask you questions, because I was really just leading you. Beginning with the language. At the Judges National Conference of 2009, the judgment you've just referred to and the language generally employed by the SCA with reference to the judgments of the High Court judges and courts of equivalent status was debated. You remember?
Very well, CJ.
Judge Lohodi was quite vocal about it, and it resulted in a formulation of a provision in the Code of Judicial Conduct to the effect that appellate courts must be very careful about the language they use with reference to their colleagues in other courts. You remember that?
I do, CJ. I was there. I remember.
Okay, yes. Now, turning to something else, who distribute work to judges at the SCA?
CJ, this is the debate.
And what is the criteria?
CJ, let me explain this. This is the debate that I lost. And it's very passionate and close to my heart. What normally happens, as I understand it, the head of the court would prepare a roll and prepare various panels. And what would happen if matter number one, the senior judge is DP Petse and 4 others. Senior Judge Petse would have the discretion to decide who should scribe in that matter. And it cascades downwards. And after Petse, let me put it this way. The president would allocate work to herself and allocate scribing duties. And after the president, the DP, and it goes and it cascades downwards. So the presiders are the one who decides who should write what on what not to write.
Okay. Well, on a different matter altogether, and this would be my last question, or maybe the second last. You don't have to mention the name of the person, but you would recall an incident when the law researchers that I had interviewed, one after another became unavailable, and I approached you, asking you to identify one of the current law researchers whose family is struggling thoroughly financially, so that his or her contract of employment could be extended to enable him or her to support his family in view of the challenging economic circumstances. You helped me identify that law researcher, but in keeping with the commitment to help others, just explain to me how you had been interacting with that law researcher who turned out to have been one of your own law researchers.
Thank you, CJ. As soon as I arrived at the CC, and actually this is what I do in all the courts that I've been, I make it my business to inquire on the socio-economic status of the people that I work with and the people that I interact with. You may not know this, CJ. This is what I do as a way of satisfying myself that the clerks at the Constitutional Court are well looked after, well catered for. I would sit with them, not only my clerks, even clerks from other chambers, to understand where they come from, to understand the challenges that they have gone through. Because, CJ, if somebody like me, who is not able to assist them, they look up to me as a beacon of hope or that shining light that can help them navigate through. So it is through that process that comes obviously naturally that I was able, when I sat with the clerk and understood that clerk's plight, and it really pained me when I understood his condition. And CJ, I quickly identified that that particular clerk had not finished his attorney's examination, and then said, every afternoon when you don't have a matter, I will sit down with you, we will prepare, because he was going to write, we will prepare the examinations. So that's what I did. And that's how I knew that the clerk's condition was dire. And I'm happy to say that I was happy when you inquired and it became a natural thing for me to say this clerk whose contract was going to expire would have been in deep trouble in terms of looking after himself and his family. So remember, umuntu ngabantu. I had to help.
And how had you been helping him? And how did you tell me you had intended to help him? Had he not, had his contract not been extended?
It worried me, CJ, because he didn't know where he was going. And I had to eavesdrop or whisper to you to say, CJ, there is this position. If you could find it in your heart, in your space, in chambers, where you could accommodate this person, and for which you agreed because your two clerks have decided not to take up the appointments.
Yeah. And you indicated that you had been helping him financially and you are prepared to continue to do so. Am I mistaken?
Thank you, certainly, CJ.
Yes. Thank you, Judge Mathopo. You are excused.
Thank you, CJ. Thank you, Commissioner.